We cover these in paragraphs 11 and 15 of our written submissions on what we perceive or understand to be the presidential immunity. In our humble submission, my lords, this is a very important time whereby the court is being asked to rule on this important matter for the first time. And it's only fair that everything that bears on it should be brought to the court. My lords, the first point of call is Article 143, sub-Article 2 of the Constitution. Without any codification, my lords, the article provides for immunity in the following words: civil proceedings shall not be instituted in any court against the president or the person performing the functions of that office during their tenure of office in respect of anything done or not done in the exercise of those powers under this Constitution. Two things that are important. I will be juxtaposing this against judicial immunity. It will be noted there is no qualification to the immunity granted by Article 143(2). Where he may commit a civil wrong. Before we go further, I'd like to pose the question, my lords, what is the rationale for presidential immunity? Presidential immunity is not unique to Kenya. It is a doctrine that has been adopted in many of the presidential systems. And out of the many reasons given for justification of this immunity, allow me to refer to three in a very brief manner. The first one, my lords, and this is very important, it serves to avoid destruction of the president in order to ensure effective governance of the country. No one would deny that the office of a head of state is an exacting office. And if it were that it was allowed for every Tom, Dick, and Harry to file suits against the president, it would distract him from performing the more important duties for running the state. This argument, my lords, is very well developed in the American case of Nixon and Fitzgerald. It is found on volume 9 of our, volume 9, page 1314 of the Attorney General's Board of Authorities. We would also request you to have a look at our written submissions, paragraphs 28 to 30, in that regard. The second point that can be taken in regard to the need for this immunity is the interest of national security. Again, it cannot be doubted, my lords, that in the course of doing his work, the president is fed with a lot of information regarding the national security. And not just that, he is also the chief diplomat for the country in dealing with other countries of the world. And in the course of doing this, he gets a lot of information that is useful to the state. One would wish that it will never come to a point where a court would order the president to make a disclosure. Why did you do this? What are the reasons that made you make this decision? It would clearly be not in the interest of the state, for the reason that it can injure the interests of the state in a very big way. So one of the justifications for presidential immunity is the preservation of national security. A third one I would like to mention, my lords, is the need to protect the dignity of the office of the president. It cannot again be doubted, but there are three main organs of state under our constitutional setup. And that those institutions require to act in a dignified manner so that the public can have confidence in them. One would not want at any one time to see a president being ordered to come to court and to account for his actions. To come to court at the pain of being put to jail if he doesn't. It would, in our view, be very bad for the three arms of state that are supposed to work together. It would create serious tensions that would not be good for the country. I would like to make some brief reference to the idea of juxtaposing presidential immunity and judicial immunity. Your lordships have been referred to this case time and again, Bellevue Development Company Limited against Judges Francis Gekonyo and 7 others. I had the fortune to be involved in the prosecution of this case from the High Court to the Supreme Court. One of the things that came out very clearly in interpreting judicial immunity in that matter was this: the judicial immunity extends as long as somebody is acting in good faith and you are doing your official work. And when it came to interpretation, if that were to be regarded as a limitation, when it came to interpretation of Article 106, their lordships were very clear that despite those apparent qualifications, this was absolute and there was not going to be some kind of an interpretation that allows suits to be filed against judges, and then the issue of whether he or she was acting in good faith should come to be considered. Because by the fact of allowing a suit against a judge, it means already you have subjected him to trouble for coming to a particular decision. And so, my lords, when you retire, I request you to consider, or rather compare, the provisions of Article 106 in regard to judicial immunity and Article 143. When you do that, my lords, you'll find that in Article 143, there is no codification at all in regard to the immunity of the president, unlike in the case of judicial immunity, where one can read some apparent codification when we talk about acting in good faith. So my view and our submission is this, that indeed the court was wrong to put a codification on the words of Article 143, which is totally unwarranted, because this immunity in our humble submission, is a functional necessity. Without this immunity, the president cannot operate in the manner that he is expected as head of state and head of government. And in our humble submission, as long as he is acting in his capacity as president, he cannot be sued during the time that he is president. But then the question arises, is it that we have created a monster under these provisions of the Constitution? Far from that, my lords, there are provisions for questioning the decisions of the president that affect a particular citizen of our republic. I would like to refer to one or two matters here. The first one, my lords, is this. You can always sue the Attorney General through judicial review procedure for actions done by the president in the name of the government. So it does not mean that a citizen who has a complaint, a grievance against the president cannot have his grievance attended to the present law. Number two, even if you cannot file a suit against the president during the time that he is the president, there is clear provision in Article 143 that your course of action is sustained and you can file that course of action against the president when he retires. And of course, like the American Supreme Court said, if the president is involved in gross violation of the laws of the state, there is that possibility of initiating impeachment proceedings against the president. So a humble submission, my lord, is this immunity does not create a monster and is totally warranted in law to enable the president to effectively carry out his duties as president. And again, my lords, there is a further exception. If the president commits crimes against international treaties or what is deemed to be a crime under the international treaties, there is no immunity he can be dealt with under the international law. So, my lords, taking into account the practice in the other jurisdictions, which we have incorporated in a summary manner in our written submissions, and taking into account the clear words of Article 143, it is our humble submission, my lords, that the Court of Appeal erred in holding, contrary to the express meaning of those words, that a president can be sued in his private capacity for omissions or acts of commission committed by him during his reign as president. So, my lords, In the light of the argument made by the Honorable Attorney General and the arguments that we have made today, we respectfully beseech this court to make a finding that, contrary to what the Court of Appeal did find, the President of the Republic of Kenya, or the person performing the functions of that office, enjoys absolute immunity from civil proceedings during his term of office in respect of anything done or omitted to be done in the exercise of the powers under the Constitution. He cannot be sued in a civil court at all. Number two, the other prayer that we seek today is that civil proceedings cannot be instituted in court against the President or the person performing the functions of that office during their term of office in respect of anything done or not done by them in their capacity as President. My lords, in regard to that issue, I would like to rest our argument at that point, unless your lordships want me to.
Just correct this. It's supposed to be 160, not 107.
Yeah. I just want to correct a wrong reference I've made. I have made a reference to Article 106 in regard to judicial immunity. In effect, it is Article 160.
May it please the court, I will deal with issue number 2 on behalf of the 20th respondent. And in doing that, my task is to try and persuade you today that the Court of Appeal came to the wrong conclusion in determining that the President cannot institute or commence the process of amending the Constitution through a popular initiative. I'm indebted to my learned friends who've spent time on this, Mr. Karori Kamau, Mr. Wambulo, Mr. Kuyoni, Mr. Eric Gumbo, and others. I will try in getting you to the destination of overturning the Court of Appeal, not to touch on anything they've touched on. I have 3 planks on which I build the arguments of the 20th respondent. The first one is that this court settled the position in the Interim Independent Electoral and Boundaries Commission, that's in the year 211 EKLR, that the provisions of the Constitution should be read as an integrated whole, each sustaining the other. And I will be arguing that the conclusion of the Court of Appeal does injustice to this, does violence to this conclusion that the court came to. The second one is that I'll be looking at the twin functions of appellate counsel and the appellate court. Let me start with the function of the appellate court, which is simply to review the procedures and decision of the courts below in this case, to make sure that the proceedings were fair and that the law was applied correctly. And there's 2 things that we're dealing with here. Were the proceedings fair, and was the law applied correctly? With regard to the 20th respondent, I think the determination of the Court of Appeal that the 20th respondent had not been served and the proceedings against him were therefore unfair. I think going further to determine that he was not, or he is not able to initiate a popular initiative is wrong. But more importantly, the conclusion of law is wrong. With regard to appellate counsel, one of the most important functions of appellate counsel is to work with the appellate courts to settle the law. In this case, therefore, the relevance of this is that when Professor Githu Muigai tells you that the Court of Appeal was wrong in determining that absent all the commissioners or absent a minimum of 5 commissioners, the IEBC could not conduct or could not run with the process of verifying the signatures or indeed conduct a referendum. What he is, in other words, saying is that the conclusion is on the basis that the commission is synonymous with the commissioners, which is wrong. The importance of this point is that other commissions have found themselves hamstrung when they have no commissioners. Unfortunately, the Ethics and Anti-Corruption Commission, which has suffered the brunt of this, has not had occasion to argue this before you. So the invitation here on behalf of Appellate Council is to settle this so that we minimize the arguments in the lower courts. But let me jump straight into the 3 arguments that I want to make to demonstrate that the Court of Appeal was wrong. I'd ask you to look at the structure of the Constitution. Just look at the first 4 chapters. It's not by accident that they are in the order they are in. And just very, very quickly, you have the sovereignty of the people and the supremacy of the Constitution. Chapter 1, you have Chapter 2 is a republic, Chapter 3 is citizenship, Chapter 4 is a Bill of Rights. I'm not suggesting that there is a hierarchy. I am simply saying that it is not by accident that you have them in that order. And by Article 1, Sub-Article 2, the people may exercise their sovereign power either directly or through their democratically elected representatives. Now, the fallacy of the conclusion of the Court of Appeal, and I say this with tremendous respect to the court, is that what they have determined in saying the president cannot initiate an amendment to the Constitution through the popular initiative is that the people can delegate sovereign powers to those they elect, including the president. But the ones they donate the power to have no business initiating changes through a popular initiative. These are inconsistent in my humble view. You can't say the people can donate their sovereign power, but those they donate to cannot run with it the whole way. In other words, they can only do certain things. If it was intended by the people to have certain qualifications, this would have been built into the Constitution. The second point I want to make is I would like to invite you, when you retire, to look at Article 19. Now, the conclusion of the Court of Appeal that the president cannot commence the changes to a constitution through a political initiative cannot be reached without amending this constitution. And why do I say that? Let's start with Article 19, Sub-Article 1. The Bill of Rights is an integral part of Kenya's democratic state and is a framework for social, economic, and cultural policies. Sub-Article 2, the purpose of recognizing and protecting human rights and fundamental freedoms is to preserve the dignity of individuals. You cannot reach the conclusion the Court of Appeal reached without adding these words here after the dignity of individuals, excluding the head of state, the deputy president, governors, and other elected people. That is what they say, in effect. Let's look at Sub-Article 3, and I will not dwell on this because Mr. Karori Kamau spent some time on these. The rights and fundamental freedoms in the Bill of Rights belong to each individual. Again, you have to read in the words, excluding the president, the deputy president, governors, and all other elected persons. That's what the Court of Appeal is in effect saying. Let's look at what the Article 20 then tells us. Sub-Article 2, every person shall enjoy the rights and fundamental freedoms in the Bill of Rights to the greatest extent. Again, the conclusion of the Court of Appeal could only be reached by inserting words after every person, excluding the president, the deputy president, elected leaders. But there's another point to be made here. You note that here the word is every person. If you go to Article 260, person includes artificial persons, it includes associations. What the Court of Appeal has said is that while even companies have the right to enjoy this right, the president does not have. Why? Because he vied and was elected. With respect, that is stripping of his rights. With respect, that conclusion is wrong. For these reasons, and those advanced by my line friend, Mr. Waweru Gatonye, we'd urge you to set aside the order of the Court of Appeal. One last thing with regard to Mr. Morara Omoke's appeal, because he's the appellant. We will not, for good order's sake, I think, be addressing you. It's that he did not challenge the conclusion of the Court of Appeal that no service was effected on the president, the 20th respondent, and therefore the proceedings against him were set aside in their entirety. Without having challenged that conclusion, my learned friend of the appellant cannot ask for costs. Costs follow the event. The only person who can ask for costs is the 20th respondent because he was not served. Those are my submissions. I'm much obliged.
Thank you very much. We will now have Mr. Isaac Arwoche, the 19th respondent.
Good morning, Your Lordships.
Good morning.
First clarification, I seem to have been allotted 30 minutes, yet your directions are suggested that I have 1 hour. Can that be clarified before I proceed?
Clarification, you are responding.
Your directions initially was that I had 45 minutes. And yesterday you made the directions that everybody has an additional 15 minutes, and therefore I should be having 1 hour as opposed to 30 minutes.
1 hour, please. Okay. Yes, that's correct.
Thank you. So hopefully the timer controller will adjust that to help to guide us. I have filed before this court a response to petition number 11. It was filed on the 14th of October. I've also filed a response to the petition of appeal in number 12, dated 11th of October, filed on the 14th. And I've also have my submissions that are filed on the 9th of December. I have not filed any digest, list of authorities and the like, and there is a reason for that. And it has to do with the role of the court. This court is not bound by the decisions of any court anywhere in this world, not even by your own decisions. I have learned this the hard way on at least 2 visits before this court. The first time was, I think, in the year 2013, whereby I relied on your advisory on the gender representation issue. And as part of that advisory, you were touching on the matter of when can a matter involving presidential elections and nominations be brought before this court. And in that advisory, you suggested that one does not have to wait until the declaration of a presidential election result before bringing the matter before you. But as long as we're in a presidential election season, if there are issues that have arisen, one can bring such a matter before you. And at the time, there was such a matter which I brought before this court concerning the nomination of 4 presidential elections at the time: Uhuru Kenyatta, Raila Odinga, Musalia Mudavadi, and Peter Kenneth, whereby I'd raised the issue that the nominations were null and void. Yet the IEBC had accepted those nominations on the grounds that there were still public officers who were not exempted by Article 137, and therefore IEBC should never have accepted the nominations. They were not members of Parliament. Parliament had been prorogued at that particular point in time, about 2 weeks before the nominations. Yet IEBC cleared them, and when I brought the matter before this court, the court refused to follow what it had advised in its advisory. It simply said it had no jurisdiction. My opposite number on the side was learned counsel Paul Nyamodi, and Paul Nyamodi simply reminded the court follow the text of the Constitution. Your jurisdiction kicks in only after a declaration of a presidential election result, and not as you are suggesting in your advisory. And so you threw out your advisory and simply resorted to the to the text of the Constitution. That was the first time. Second time was about 2.5 months ago, when I brought the issue of the recusal of 3 judges before this court, and I'd relied on the interpretation of Article 50 by Lady Justice Jokindungu. But when the matter came before you, again, you threw that particular interpretation aside, and you relied on the express text of Article 50, and you said this applies only to criminal matters, it doesn't apply to non-criminal matters. In other words, you are not bound by the decisions of any court, your own decisions included. And therefore, I thought, well, I could do what everybody else is doing, give you a whole list of authorities from world-leading scholars and the like, but at the end of the day, it doesn't bind you. It can act as some measure to persuade you, but really doesn't bind you. So what I've decided to do this time around is to limit myself to only that which binds you. The Constitution. Articles 1, 2, 3 basically talk about the binding effect, the supremacy of this Constitution, the binding on everybody, and since that is all that binds you, and any other law under the Constitution, that is all I'm going to stick to in my submissions today. Such that whatever I speak should be what is binding to you, and anything else not binding to you is entirely at your discretion. You can accept it or reject it, depending on your view at the time. The first issue I deal with, as you laid out, concerns the basic structure doctrine. I'm basically saying this doctrine does not apply to Kenya. My reason for saying so is different from the reasons that have been advanced before this court. I'm appealing and relying on Article 2.1, which talks of the supremacy of this Constitution and the fact that it is binding on everybody. All state organs, everybody, every person is bound by this Constitution. We have no higher law than this Constitution. Therefore, we have to abide by this Constitution. When you study the basic structure doctrine, you find that the doctrine, and here I think we need a clarification, there is a distinction between the basic structure doctrine and the basic structure in the Constitution. Our Constitution has structures, a basic structure, but the doctrine is something different from the structure. The doctrine basically posits that if you are attempting to amend this Constitution and you touch upon its basic structure, then, as was very clearly laid out by the High Court, you have to follow 4 sequential steps. If you don't follow those 4 sequential steps, irrespective of the amendment provisions in the Constitution, whatever purported amendment you're trying to convey and get across is not valid. This is in conflict with the supremacy of this Constitution of ours. Is our Constitution supreme, or does it have a higher law called the basic structure doctrine sitting atop our Constitution? If our Constitution is supreme, we cannot have another law, it doesn't matter what name you call it, sitting atop our Constitution and using that higher law to construe our Constitution, and using that higher law to even nullify the amendment provisions of our Constitution. If our Constitution is supreme, then it is supreme, and no law can purport to construe it. No law can purport to nullify its provisions. No law can purport to invalidate its provisions. That is the first point. The second point is Article 1, Clause 1, flowing from the preamble to this Constitution. We, the people, gave ourselves, after fully participating in the making of this Constitution, we adopted and enacted and gave ourselves this Constitution, and even to subsequent generations. Then the very first article in the Constitution says, the manner we exercise our sovereign power is only in accordance with this Constitution. We limited the manner we exercise our sovereign power. It was a self-imposed limitation, not imposed by anybody external to ourselves. The basic structure doctrine talks about something different. It says we cannot limit the manner we exercise our sovereignty, our sovereign power. If we're trying to amend this Constitution and it touches on the basic structure of the Constitution, then we have to go outside the Constitution. In other words, that is in conflict with the self-imposed limitation that we imposed upon ourselves, saying that we can exercise our sovereign power only in accordance with this Constitution. If we did not impose this limitation upon ourselves, then of course there might be some merit in that aspect of the basic structure doctrine, whereby we can go outside the Constitution and amend it. We can have coup d'etats, revolutions, uprisings, or whatever. But we as a people of Kenya, we said the only manner we are going to exercise our sovereign power is in accordance with this Constitution. Therefore, when the basic structure doctrine talks about the possibility of amending this Constitution in a manner different to what we have laid out in this Constitution of ours, for example, using the 4 sequential steps, that is not in harmony with Article 1, Clause 1. That is not only in accordance with this Constitution, the self-imposed limitation we the people imposed upon ourselves. Therefore, that basic structure doctrine is in conflict with this Constitution. That basic structure doctrine challenges the legality and validity of Article 1, Clause 1. That basic structure doctrine is challenging our own sovereignty. Who is boss in Kenya? Is it maybe President Martha Koome, President of the Supreme Court, or President Uhuru Kenyatta, President of the Republic of Kenya, or David D, Chief Champion of the basic structure doctrine in Kenya? Or is it us, the people? Who is boss in Kenya? This is a fundamental question that we have to address. This doctrine challenges the legality and validity of provisions of this Constitution, including the very first article and first clause. It challenges the amendment provisions of Chapter 16, Articles 255, 256, and 257. If we were to apply Article 2, Clause 4, we would invalidate the basic structure doctrine on account of its inconsistency. It's a null, void, and invalid doctrine as applied to Kenya on account of its inconsistency with our Constitution, which we gave ourselves. We have a clause, Article 2, Clause 3, that deals directly with the jurisdiction of the courts and other state organs with respect to entertaining any challenge to the legality or validity of this Constitution, either by any court or state organ or before any court or state organ. Now, I know this matter wasn't initiated by the courts. It was initiated by petition E-282 of 2020 in the High Court. It was a matter that was placed before this court. But it is a challenge to the legality and validity of this Constitution, and therefore, under Article 2, Clause 3, this court, the Supreme Court, the Court of Appeal, the High Court, any court in Kenya, and any state organ in Kenya has no power, no jurisdiction to entertain it within its particular forum. In other words, since you have no power, no jurisdiction to entertain a challenge to the legality and validity of this Constitution, the orders of the High Court, as affirmed by the orders of the Supreme Court, must be vacated. They're null and void. They don't apply. You have no power to approve or say it's valid in Kenya. None. No power. And since you have no power to do that, the logical thing to do is simply to vacate those orders. We go back to default mode before this matter was placed before this forum of the courts. So that is a fundamental and critical matter, and that is the reason why I have not bothered addressing a lot of the very erudite articles, very erudite submissions by highly learned and reputable scholars who are friends of the court, whether in the High Court, Court of Appeal, and even in the Supreme Court. We simply don't have the power to entertain this doctrine in this court, in this country. Maybe in a different country, fine. Maybe if we did not have the self-imposed limitation in Article 1, Clause 1, fine. But unless and until we change Article 1, Clause 1, whereby we permit ourselves to exercise our sovereignty in a manner not in accordance with this Constitution, until that day, we cannot entertain this doctrine in Kenya. Now some might say, now, Bwana, if you're speaking this way, you probably brought reggae back into business. Reggae was a tough time, now you're bringing it back. Somebody will say, now you're actually pleasing President Uhuru Kenyatta, because he has been saying in all of any function he has, this thing is coming back, this thing is coming back. I am not necessarily saying so. What I am saying is that the basic structure doctrine is a legal device that has been used by the courts in an effort to promote democracy. That is a paraphrase from the submissions of my learned friend, President Nelson Harvey, on behalf of Devin D and his team. If you look at the words in the judgment of Patrick Kiage, Justice in the Court of Appeal, he said he was using the basic structure doctrine as a defense mechanism for the Constitution. He cannot stomach anybody trying to rubbish and dismember this Constitution, and therefore he's using the basic structure doctrine as a defense shield or a mechanism to defend this Constitution. But then Article 1, Clause 1 says very clearly, our sovereignty is to be exercised only in accordance with this Constitution. We delegated our judicial authority to you, the judges, which means your authority as judges is limited to our sovereign authority. And since we have limited the manner we exercise our sovereignty to only in accordance with this Constitution, you cannot go beyond that. You cannot use extra constitutional measures, even in an effort to defend this Constitution of ours. You are confined only to using legally and constitutionally permitted defense mechanisms and not go beyond what is permitted. If I'm to use a football analogy, you have attackers and you have defenders. If you're trying to defend your team from having a goal scored against it, you can defend by a fair tackle, tackling the ball. Or you can defend by an unfair, illegal tackle, tackling the player. If you tackle a player, you'll be penalized for committing a foul that is against the rules of football. That is basically what I'm saying over here. The basic structure doctrine in Kenya is not allowed by our Constitution. Yes, it can be used as a defense mechanism elsewhere in the world, but it is not permitted by our rules. Therefore, it is not open to us to use it in the defense of the Constitution. We have to use other different mechanisms that are allowed in our Constitution in defending our Constitution. I think by that particular point, I'll leave the matter there. I'm not going to delve into any other detail because we don't have the authority to deal with it. It's simply for vacation. Now, what about defending the Constitution otherwise? We have other mechanisms. For example, Article 2, Clause 2. This article states basically that no person may claim or exercise state authority except as authorized under the Constitution. You have a lot of arguments being submitted over here. The president has authority to initiate the constitutional change process and all that. As an individual, no problem. He has his political rights. After all, he stood in the last general elections as a president defending his presidency or seeking another term in his presidency. He was exercising his political rights. He is not denied his political rights simply because he's president of the Republic of Kenya. And therefore, I will not attempt to deny him his political rights in other spheres outside elections. Since it is open to any citizen to initiate, as a citizen, a proposal by way of a popular initiative to amend the Constitution, he can, as a citizen. What Article 2, Clause 2 prohibits is any person exercising state authority except as authorized under the Constitution. The Constitution has nowhere authorized a president to initiate and use state authority in initiating a constitutional change process. We had the BBI. We've just been referred to Kenya Gazette notices signed by the President of the Republic of Kenya and Chief of the Kenya Defense Forces. He was exercising state authority, doing what the functions of his office does not permit him to do. He was violating Article 2, Clause 2. This is the one article the AG and others of the similar persuasion have shied away from. They should quote Article 2, Clause 2. Any public servant, any state officer, as an individual, can initiate any amendment to the Constitution, no problem. But just don't exercise state authority in the process of so doing. Don't use public funds in so doing. Don't use public facilities in so doing. When the president seeks re-election as president, if he's doing it properly, he doesn't use state funds. He uses his own money or his political party's money and things like that. He doesn't go to the National Treasury, come on, give me this budget to mount my re-election. No. He fights for that as an individual. Likewise in this particular case. So Article 2, Clause 2 prohibits the usage of state machinery in purporting to change the Constitution. So any state officer, any public officer wants to change it, go ahead as an individual, just like the rest of us, but just don't use state resources or state machinery in so doing. I'll now turn to the issue which is generating a bit of some controversy here, presidential immunity. I'm the one, through my petition in the High Court, E426 of 2020, who brought or dragged the president to court and asked for the orders that I asked for, based on Article 143, Clause 2. The pronouncement that came from the High Court, as affirmed by the Court of Appeal, was not exactly what I asked for. I simply said that you can institute civil proceedings against a president for actions that he undertakes or omissions outside his functions of office. In other words, Article 143, Clause 2 protects him, gives him immunity when he's performing the functions of office as president. So I asked for clarification. You can bring a suit against a president if it touches on a matter outside the functions of presidential office. And I basically said, when he was busy setting out Kenya Gazette notices, establishing the BBI steering committee, he was acting outside the functions of office, because there is nowhere where the Constitution authorizes him to engage himself in constitutional change matters outside Article 256. Yet here he was establishing a public body to consider the change of the Constitution. Because he had acted outside the functions of his office, Article 143, Clause 2 did not prohibit us from instituting an action against him. And that is basically what I had asked for. But what the High Court came up with was that you can sue him for any conduct, his actions or omissions, that are contrary to the Constitution. The pronouncement of the court was wider than what I had asked for. I had confined myself to conduct outside his functions of office. But if you apply what the High Court said, you can sue him for anything that he does that is unconstitutional. Unconstitutional includes both functions within his office and functions outside his office. And that is the bit that I disagree with. And I'm saying that particular order was wider than my prayer. I'm urging this court to revert to my prayer and not go beyond my prayer to what the High Court and as affirmed by the Court of Appeal went. I'll give an example. If I use the pronouncement of the High Court and the Court of Appeal as law, and if I am Justice Joel Ngugi or Justice George Odunga, who are involved in this matter at the High Court, because they ruled in the manner that they did, and the president doesn't like them because they scuppered reggae or they messed up BBI, his pet project, when other judges were being promoted to the Court of Appeal, they were left out I mean, for us, Kenyan citizens speculating, we say the only reason why they were left out was not because of their inability to act as judges, but it was simply because they came up to a determination that messed up the president's plans. Now, if I rely on that particular order from the High Court and the Court of Appeal, Justices Ngugi and Odunga can actually go ahead and sue the president right now, maybe in the Employment and Labor Relations Court, for the deficit in their remuneration compared to what they're earning now as High Court judges, compared to what they should be earning as Court of Appeal judges. And of course, they would have a case because that particular order allows them to do that. The president acted unconstitutionally, violating Article 166, because once he has received a recommendation from the Judicial Service Commission, he's supposed to ceremonially appoint all those judges to office. He didn't do that. But I'm saying, no, Justices Ngugi and Odunga cannot sue the president, even in such circumstances, because appointment of judges is a function of presidential office. And Article 143, Clause 2 prohibits, gives him immunity from being sued when he's performing a function of presidential office. Yes, he conducted himself unconstitutionally. Nevertheless, he has that defense in Article 143, Clause 2, and therefore the two justices have to wait until he's no longer in office. And that is where Article 143, Clause 3 comes in, limitation of time. I know it's been raised by the AG, it's been raised by the president's team, trying to misconstrue Article 143, Clause 2. No, it was there precisely to protect the rights of such persons, such as Ngugi and Odunga. If they decide once Uhuru is no longer in office that they want to sue him, they can, but they have to wait. They can't do it now. And that is why Article 143, Clause 3 is there. That same Article 143, Clause 3 can also apply to minor traffic offenses. For example, if you look at Section 50 of the Traffic Act, if somebody has committed a traffic offense, the person intending to prosecute you has to inform you within a particular defined period, 14 days or so, or send you a notice to your last postal address and things like that. Now, we know every once in a while we see President Uhuru driving vehicles and everything else. He could commit a minor traffic offense just like anybody else. But because that particular criminal offense or traffic offense, as the case may be, does not fall under Article 143, Clause 4, one covered by an international treaty, you can't sue him. But since the Traffic Act puts very clear defined time periods, 14 days to do A, 14 days to do B, Article 143 protects the rights of the DPP to bring any prosecution against the president if he was involved in such a minor traffic offense as the case may be. So Article 143, Clause 3 is not superfluous as suggested by the AG. The president does not have absolute immunity. He has limited immunity with respect to civil proceedings. Also, we need to get some clarification here. Article 143, Clause 2 gives him immunity against civil proceedings being instituted against him. It doesn't talk about immunity against constitutional proceedings. It doesn't talk about immunity against electoral proceedings. After all, we have presidential election petitions. The president is sued. He was sued by Raila Odinga in the last presidential election petition. And that was valid and it was admitted before the court and the matter was dealt with. In other words, we are only talking about civil matters. Constitutional matters can be brought against the president. Electoral matters can be brought against the president in his own name. So when we hear the president's team trying to argue for blanket, absolute immunity on grounds outside the Constitution, you must not allow yourself to be misled on that particular path they're trying to lead us. In fact, they're calling upon the case, the Bellevue development case. It was decided, well, at least the lead judgment in the Court of Appeal was by Patrick Kiage. I've read through the case, and I believe that was a simple case of judicial overreach. Judges could be accused of basically protecting themselves and using their position, their office, to protect themselves as opposed to stick to the letter and spirit of the Constitution. If we, the people, in the exercise of our sovereignty, says you can't sue a judge except if they act unlawfully or not in good faith, we knew exactly what we're talking about. We cannot have a judge come and say, no, judges are superhuman. They're super righteous. I mean, you can't have a judge doing anything unlawfully or out of good faith. So therefore, I'm going to ignore those particular phrases, those qualifications. Unlawful, without good faith, that's out of order. That judgment was wrong. And when it came to the Supreme Court should have shut it out, but it did not. And I think even the Supreme Court was wrong. But then, as I said at the very beginning, you are not bound by the decisions of anybody, not even your own decisions. Therefore, don't allow yourself to be bound by that wrong decision which you affirmed, which came from the High Court. The letter of the Constitution in terms of judicial immunity is exactly as we put it. If you act unlawfully, if you act without good faith, you can be sued. I know the lower courts won't do anything different to what you've said because they're bound by your orders. But now we're calling upon you to do the right thing. Be faithful to the Constitution. The sovereignty we delegated to you was only in accordance with this Constitution, not beyond this Constitution, not by the exercise of judicial overreach or any other judicial games people play. No. Just like we're supposed to be faithful, you too are supposed to be faithful to that particular Constitution. And therefore the Bellevue decision case is wrong. Depart from it and do the right thing. Because right now the president is saying, well, judges, you gave yourselves absolute judicial immunity. The Constitution did not, but you gave yourself absolute immunity. Come on, do me a favor too. Give me, the president, also the same judicial absolute immunity that you gave yourselves. That is basically what the president's team is asking over here. We cannot have that. No. Who is boss in this country, I asked earlier on. Is it Martha Koome? Is it Uhuru Kenyatta? Is it Devin D? Or is it us, the people? Who is boss? If we, the people, are boss, then our word should rule and prevail. And if we put qualifiers in judicial immunity, like unlawful, not in good faith, we mean exactly what we say when you put those particular phrases in the Constitution. They're not to be ignored by judges. You're supposed to act faithfully in upholding that Constitution. That is the delegated authority we gave you, not to act beyond the authority we gave you. So Bellevue decision is wrong. Uhuru Kenyatta as president cannot rely on that in an effort to get himself absolute immunity. He does not have absolute immunity. Section 3 of the Supreme Court Act talks about this court using history in an effort to get to the text and context of matters and all that. Section 14 of the retired Constitution was dealing with presidential immunity. You can compare that with Article 143 of the current Constitution, and you'll find that on the criminal side, we reduced the immunity of the president because we inserted Article 143, Clause 4, whereby we allowed him to be sued in criminal matters if the matter touches on an international treaty which allows him to be proceeded against. So we reduced his immunity. Very consciously we did that. When it comes to Article 143, Clause 2, dealing with civil proceedings, in the retired Constitution, you could not institute or continue any civil proceedings against the president. Then he had absolute immunity against civil proceedings. But under the current Constitution, you're only prohibited from instituting, which means if he had a pre-existing civil matter before he became president, that continues, which means again, we reduced his immunity in the current Constitution. So we, the people, reduced his immunity. The president seems asking us, asking you as a court, basically to enhance it and give him absolute immunity. We cannot have immunity for impunity. No. We want a president who lawfully abides by this katiba of ours, lawfully abides by our national legislation. We cannot have him doing anything he feels like president, as asked by the second prayer of the president's team. The first prayer is faithful to Article 143, Clause 2. But the second prayer says he wants immunity for anything he does as president. If you grant him immunity for anything he does as president, then he'll be immune from any action such as what he did in this BBI case. He exercised state authority in pushing the BBI case, yet he had no authority under the Constitution to appoint the BBI steering committee to engage himself in constitutional change conduct. That is not allowable. He wants to be given more than we, the people, gave him. And you, as the Supreme Court, in being faithful to only in accordance with this Constitution, cannot. In fact, you have no power to enhance his immunity. I know they've given us very wonderful reasons, dignity, confidentiality of state matters, etc., etc., etc. Yes. But let us look at the record. How many cases in the last 11 or so years since the Katiba has been in place, 12 years almost, have been brought against the president on civil matters? On civil matters. Forget about electoral matters. Forget about constitutional matters. Civil matters. Frankly speaking, I'll be very hard-pressed to find any. Kenyans are not litigious against the office of the president. No. We respect that particular office. Even if you take my case in 2013, that was before Justice Lenaola, it was on a constitutional matter. It was not on a civil matter. I was not seeking any money from them. No. So let us be faithful to this constitution of ours. The president's team, they want to be granted immunity for impunity. We say no. We are a lawful, law-abiding nation. The rule of law is one of the principles of national governance that we have in Article 10. We have to uphold that. Everybody has to abide by the law in this country. Whether you're president, whether you're a judge, whether you're a private citizen, all of us have to abide by the law in this country. Under Article 27, which the president's team relied on, all of us are equal before the law, even if you're president. We do not have two tiers of citizenship, two tiers of persons. We are all equal before the law, and all of us must abide by this law. I will now touch on very briefly on the IEBC petition of appeal, essentially on the issue of the lower courts relying on a repealed law to come up with a determination that it didn't have quorum. I agree with the submissions of the IEBC on that particular point. Lawmaking is a preserve of parliament. They make legislation. These were matters of legislation. When parliament repealed the provision of requiring a quorum to be 5 people, and then subsequently the court ruled as unconstitutional the replaced law, the previous law had already been repealed. It was no longer in existence. Unless Parliament revives it, it remains repealed. And on that basis, we cannot use a repealed law as a basis of declaring IEBC to have been without quorum. IEBC actually acted with quorum as per the Constitution. It had 3 commissioners. And on that particular score, I will not fault the IEBC. If I want to fault anybody, I will fault the people who are responsible for setting up the committee responsible for putting in place the commissioners to be replaced, which is a parliamentary function. And maybe the president who's supposed to write and inform the parliament. In other words, if any blame should go anywhere, it should go to the appointing authorities, not to the victim commission. IEBC was here just a victim of circumstance, not of its own making. And the ones who were supposed to have remedied the situation did not remedy the situation. They were not brought before this court on that particular issue, so I think we can just leave the matter to rest there. I will touch on briefly to the other petition of appeal, Morara Omoke's one. I know there's been almost like a chorus saying that he's been asking the wrong question, whether we should be having multiple questions or singular questions in a referendum, whether he jumped the gun, he should have waited until we got to the stage of Article 257, Clause 10 and all that. But I think we need to reset something which was even mentioned by the AG's team and others who spoke in that particular regard, which is, in a referendum, we are voting on a bill. It is a bill that goes to Parliament. The parliamentarians vote on a bill. They don't vote on multiple questions, they vote on a bill. In a referendum, it is a bill that is put before the people, and they basically say yes or no to the bill. What was not said before this court was, what are the contents of this bill? That was the bit that was not mentioned by the AG, the President's team, the IEBC, and others who supported them like the Parliament. If you look at Article 255, 256, and 257, it is extremely clear, and it is very consistent. In fact, there is no evidence of even a single inconsistency. A bill can only deal with a single subject matter, a single amendment. Therefore, yes, we vote on a bill, but that bill can only contain one subject matter. So let's say, for example, it was a bill touching on Article 255, Clause 1, Article Subarticles A to J. You cannot have a bill with all those 10 subject matters mentioned there. That is not in harmony with Chapter 16. You can only have one bill with one subject matter. If you want to address all those 10 subject matters, then you have to give the people 10 different bills and have 10 different bills circulating all over the country, each particular bill meeting the threshold of at least 1 million registered voters supporting it. That is what they should have mentioned. And if that is the case, which I believe is the case, then the issue raised by Morara Omoke's petition of appeal is actually addressed. We'll only be having one question in one bill in a particular referendum. Even if we had 10 issues come at once, we can have 10 different ballots. One ballot for each bill, just like we have 6 different elections in a general election. A voter is given 6 different ballot papers and you vote for each different position. So in this particular case, we should be given 10 different ballot papers, a ballot paper for each bill, and we vote individually for each bill. That is basically the position in Articles 255, 256, and 257. And that is basically what this court should clarify. Cite that when parliamentarians within Parliament are debating on constitutional change matters, they restrict themselves to one issue in a constitutional amendment bill. And the same applies to anybody pursuing the popular initiative route. One issue for each constitutional amendment bill. That is the clear record in the amendment chapter of the Constitution. And that also addresses one of the defense mechanisms we have inbuilt in this Constitution against the hyper-amendment culture that we had from 1963 until we had this Constitution in 2010. I know some of us have tried to bring the basic structure doctrine as a defense mechanism, but that is not permitted by our Constitution. But what we put in place here to forestall the culture of hyper-amendability of this Constitution is that if you want to amend it, you can only bring one issue at a time. And therefore it will take a pretty long time. Knowing how long it takes to collect 1 million signatures, how long it takes to do all these things, it might take maybe 74 years. If these people who are promoting the BBI bill wanted to have all the different issues in the BBI to be passed by this particular country. So it is an inbuilt defense mechanism we have in our Constitution for its defense. I am urging this particular court to uphold the inbuilt defense mechanisms and not to import illegal, unlawful, unallowable defense mechanisms as a basic structure doctrine in the defense of this Katiba of ours. So basically, I'm going to wrap up, and whatever time that I don't use, I am going to very willingly and gladly donate all of that time to Morara Omoke, because other parties have donated the time to the AG and the IBC. I think let's give the other petition of appeal also some fair time. So any time that I don't use, I'm going to donate that to Morara Omoke and his team. But essentially, I began by asking the question, who is boss in Kenya? Is it Martha Koome, the President of the Supreme Court of Kenya? Is it Uhuru Kenyatta, the President of the Republic of Kenya? Is it David Ndii, the champion of the basic structure doctrine, as represented by President Nelson Harvey? Or is it us, the people? In this Constitution of ours, we the people are the sovereigns. We are boss. We have limited the exercise of our sovereignty to only in accordance with this Constitution, and so we must be faithful to this Constitution. Any constituted power, be it the executive, legislature, judiciary, independent commissions, must conduct their affairs to only in accordance with this Constitution, because that is the sovereign power that we've delegated to them. We have reserved to ourselves exercising our sovereign power in a manner different to this Constitution, but only when we change Article 1, Clause 1. For now, while Article 1, Clause 1 remains in our laws, we have not allowed ourselves and anybody we have delegated our sovereign power to do anything different from only in accordance with this Constitution. I think with those particular remarks, I rest my case, and I hope when you retire to your judgment, you do the right thing. Thank you.
Thank you for ending on the happy note that Martha Koome is not the boss. We the people, the sovereign people are the boss.
Take a little break and we can ask questions.
Okay, it's almost 10:20. We had intended to break at 10:30, but we still think we can take a health break now. And just to indicate that for those who have submitted, the court will make some interventions and seek some clarification or questions when we resume before we go to the next round of submissions. So we'll rise and convene at 11.